In episodes 1 and 2, we saw that for almost 150 years, the Supreme Court adhered to a literal interpretation of the Commerce Clause as allowing Congress only to regulate buying and selling across state lines. Therefore, all forms of production, such as manufacturing, mining, and agriculture, were not commerce and could not be regulated by the federal government. Now, in Episode 3, we will explore an abrupt U-turn made by the Supreme Court. Beginning in 1937, the court's rulings granted the federal government progressively more power over the country's economy. In the process, they effectively reversed many of their earlier Commerce Clause rulings. To some, this change meant that the court had finally woken up to the reality of the need to give the federal government broad control over the national economy, particularly in the face of the suffering caused by the Great Depression. To others, it was a betrayal of the bedrock principles of the Constitution, which intended to create a federal government of limited powers. This point of view is perhaps best illustrated in a statement in the Supreme Court's 1936 decision in United States v. Butler. The question is not what power the federal government ought to have, but what powers, in fact, have been given by the people. Article 3 of the Constitution establishes the Supreme Court and the other federal courts. It states, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their office during good behavior, and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office." And that's all it says. There's nothing in the Constitution itself which explicitly states how many justices sit on the Supreme Court, how the court functions, or even that it has the power to decide whether or not a law is constitutional. Increasingly frustrated with the Supreme Court's rulings which thwarted his New Deal agenda, President Roosevelt accused the court of misinterpreting the Constitution. He looked for a way to get around what he saw as their obstructionism and decided to try to pack the court. So FDR proposed legislation that would allow him to appoint 6 additional justices, thereby giving him a pro-New Deal majority on the court. Even many of Roosevelt's staunchest supporters opposed such a move as an abuse of presidential authority, but the threat appears to have been enough. In 1937, the most liberal of the 5 conservative justices, Owen J. Roberts, began to side with the liberal wing. This is known as the switch in time that saved 9, although there is considerable disagreement as to whether or not FDR's threat to pack the court was the catalyst for the change. Regardless of the cause, the result was a court that essentially reversed its decisions of the previous 40 years and then greatly expanded the power of the federal government. Congress passed the National Labor Relations Act in 1935 with the goal of preventing the injuries to commerce that they claimed occurred when employees were prevented from forming labor unions and when employers refused to enter into collective bargaining with unions. The act created the National Labor Relations Board. The NLRB accused the Jones and Laughlin Steel Corporation of violating the act by engaging in unfair labor practices. Jones and Laughlin challenged the constitutionality of the act, claiming that its objective was not to regulate commerce, but to place under the compulsory supervision of the federal government all industrial labor relations within the nation. In this case, the court departed from its earlier distinction between direct and indirect effects on interstate commerce. It now held that activities within a state could be regulated by Congress when they have such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect that commerce from burdens and obstructions. In a 5-4 decision, the court ruled the act was constitutional because the power granted to Congress to regulate commerce is absolute and may be exerted to protect interstate commerce no matter what the source of the dangers which threaten it. The court found that undoubtedly the scope of this power must be considered in light of our dual system of government and may not be exerted so as to embrace effects upon interstate commerce so indirect and remote that to embrace them, in view of our complex society, would effectively obliterate the distinction between what is national and what is local and create a completely centralized government. In 1941, the Supreme Court reinforced its position in United States v. Darby, in which it ruled that the power of Congress over interstate commerce is not confined to the regulation of commerce among the states. The court held that it also extends to activities within a state which affect interstate commerce and/or which must be regulated in order for Congress to effectively exercise its power to regulate interstate commerce. 4 years had passed since the Jones and Laughlin decision. Over half of the justices had retired and been replaced. This time, the decision was unanimous. Between 1929 and 1931, the market price of wheat in the United States plunged by 63%. One of the causes of the drop was a 60% reduction in exports due to trade barriers and increased foreign production. Congress decided to intervene in the free market to prop up prices. They passed the Agricultural Adjustment Act of 1938. Among other things, the act authorized the Secretary of Agriculture to control the price of wheat by regulating the total amount of production in any given year. As a result, every wheat farmer in America could be told how many acres of wheat he could plant. By controlling the supply of wheat, the average price a farmer who cooperated with the program received in 1941 rose to $1.16 a bushel, while the world market price was only 40 cents a bushel. Roscoe Filburn owned a small farm in Ohio. He raised poultry and dairy cows and planted a small amount of winter wheat. Typically, he fed some of the wheat to his animals, used some to make flour for home baking, and stored the remainder as seed for next year's planting. The federal government told Mr. Filburn that he was only entitled to plant 11.1 acres of wheat for harvest in 1941. Instead, he planted 23 acres. Under the rules of the Agricultural Adjustment Act, he had 3 options. He could pay a penalty of $117 for the excess wheat, 42% of its total market value. He could forfeit the excess to the federal government, or he could store the excess until the following year when it would be subtracted from his 1942 planting quota. Roscoe Filburn found a 4th option. He took the Secretary of Agriculture, Claude Wickard, to court. Mr. Filburn claimed that the Commerce Clause did not give Congress the power to regulate the production of goods that were produced solely for consumption on his own farm. The case reached the Supreme Court in 1942. The court ruled against Roscoe Filburn. This decision set a new precedent. If Congress concludes that a purely non-commercial activity will undercut the regulation of the interstate market for a product, they can regulate that activity. In reaching its decision, the court explicitly rejected its earlier distinctions between direct and indirect effects on interstate commerce. Even if Mr. Filburn's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. The court found that no individual's impact on commerce is too small to escape regulation by the federal government. That Mr. Filburn's own contribution to the demand for wheat may be trivial by itself is not enough to remove him from the scope of federal regulation where, as here, his contribution, taken together with that of many others similarly situated, is far from trivial. So in 6 years, the court went from ruling in United States v. Butler that it was unconstitutional for the federal government to regulate agriculture, to deciding in this case that the government had the power to dictate how much wheat a person could grow for his own use. In a few short years, the Supreme Court went from declaring that any federal regulation of manufacturing was unconstitutional to agreeing that the government could create an entire agency to regulate the relationship between a private company and its employees, and from ruling that Congress was forbidden to regulate agricultural production to giving the federal government the power to tell a small farmer that he couldn't grow food for his own consumption. Based on this interpretation of the Commerce Clause, Congress has the power to make it illegal for you to grow your own fruits and vegetables instead of buying them at the grocery store, or to forbid you from making a pizza from scratch instead of ordering takeout from the local pizzeria. Subsequent Supreme Court rulings have sought to explain the drastic change in the court's position on the power granted to Congress by the Commerce Clause, as demonstrated in the decisions in Jones and Laughlin Steel, Darby, and Wickard. In a 1995 ruling, the court offered the following explanation. In part, this was a recognition of the great changes that had occurred in the way business was carried out in this country. Enterprises that had once been local, or at most regional in nature, had become national in scope. But the doctrinal changes also reflect a view that earlier Commerce Clause cases artificially had constrained the authority of Congress to regulate interstate commerce. In the 70 years since the Wickard decision, the federal government has used the Commerce Clause to explosively expand its powers. We are now at the point where the Supreme Court is about to decide whether or not that power is unlimited. If the federal government can force you to buy a product or service such as health insurance, then there's nothing it can't force you to do. because there is no human decision, from the career you pursue to where you live to how many children you have, that doesn't have an economic impact. And then our Constitution, which created a federal government of limited and enumerated powers, will be rendered meaningless. Episode 4 explains the remaining steps that have brought us to this tipping point.